Well, hi again, everyone. It's Rob Ryder, and it is Saturday, the 8th of March, 2025. And today, T.I.L.A tales. A judge, Esquires, and an owner walk into a... We'll fill in the blank later. I am Rutluski Robert Allen, DOD number 12112800006, an indefinite enlistee, also known as Rob Ryder. Email address is courtofrecord@AOL.com. And my other postings and so forth, you can find on X and YouTube as Rob Ryder with 3 B's, ROBBBRYDER, and on Rumble with 2 B's, ROBBRYDER. Yeah, so here in the last week, judge, Esquires, and owner walked into a foreclosure, and certain things happened that I want to talk about. So let's see what that could be. Give me just a second here. And the case we're going to be talking about is going on in South Carolina, which they have all their records online. Very nice, right? So if you go to do a Google search on South Carolina court cases, you'll end up at this page. And we're in Dorchester County, which you would click on, which would take you to... What you would click on, it take you to a page that looks like this: Dorchester County First Judicial Circuit Public Index. And there's the case number, right? 2024 CP 1800549. Now, the interesting thing right off the bat is when you do that, and this screen will then come up and show you, well, there's the cases, right? You'll see that this case number is being used 2 different times. One is because here's the defendant twice, right? Same defendant. And one is referred to master, another one's a hearing scheduled. So there's a reason for doing it that way. One's in common pleas, one's in master of equity. So common pleas, that must be the court of law, and master of equity, that's the court of chancery or court of equity. But why is it 2 different listings, right? Because it's under case number. It's listed twice. So it's like you're being tried twice for the same crime. That's my point. But anyways, when you come to one of these, we'll just say referred to master, referred to master. Click on that one. And here in just a second, you'll come to this screen, right? And just real quick to go through some of this stuff because it's rather interesting. Look at the case parties, and it's just not the defendant, the homeowner that's a defendant, but they made the stated defendant, and they made this guy here, this George L. Clark, him a defendant, and he's the one that they bought the property from, right? So they're all defendants, but there's only one person in court. Go figure. And then I also just noticed that all these Esquires here, they have they're all attorneys, right, for somebody. And they all have last name, comma, first name. That's just the way you do it in the military. So why didn't they do that with Elam Adreen or Clark George L? Why don't they have a full legal name? I'm just saying. Well, I guess I want to show first is, look at this thing where it says associated cases, right? So these are other cases, and sure enough, there's that other number. It's the same number as this, but it shows it's an associated case. And then there's yet another case. There's actually 3 different cases going on at one time with this. Now, in this particular case, what we're looking at now, if you hit actions, you could go over here and you could download all these different documents that I might be showing. But really, they'd only be things from like the 4th. Right? This is where the first attempt was to by the defendant to say, hey, there's T.I.L.A violations, right? However, now if we go back to this associated cases, and we go to this, which is the same number, but it's a different case apparently, and we go under actions, there aren't any. So, like in this case, there's nothing happening. right? And the other case is where all the stuff is, but the guy, the defendant, yeah, the homeowners, um, had a hearing in this court, and there's nothing in here. I say court. I mean, it's all the same place. I'm just saying there's three different cases going on here. And then the only one associated with that is the first one we looked at, this one that says other. Because when we go here and we look at these, well, there's all those documents again. And then there was one other case, which is this one associated by LP. This had to do with the Liz pendens, which is a whole other case. So it didn't go away, right? This is the thing. This case didn't, it's still there. It says it's pending. This is the case that started it. And once they got the Liz pendens, then they made up this other court case that we were going to be looking at. But this one still exists. So, you know, lots of smoke and mirrors being used in South Carolina right off the bat. So again, if you wanted to go look at the stuff, you get to the proper one, you're going to be able to see the documents, right? It isn't showing up because these are all blank, and just go to associated cases and click the other number. It's the same as this. And it'll take you there. So just to show you here, we went down to, when did this case start? It started the 24th, 2024, about a year now. So all this time, the defendant had put in different motions and stuff, and nothing happened. He couldn't get a hearing. They just they ignored it. They were ignoring the paperwork. But finally, they put in one to do with that's what this motion for estoppel is, of a foreclosure, having to do with there being T.I.L.A violations, and that was on the 4th. Well, on the 6th, you know, just 2 days later, the plaintiff puts in to have a hearing, and that one got scheduled, right? So then we end up having this scheduled hearing, and well, we are where we are now. So, and then in between, there's this other one. Notice the withdrawal of estoppel filing. I have to find what they have that one in there. Because he didn't take it out. He just altered it. I didn't notice it said notice of withdrawal of estoppel filing. Going to have to keep that in mind. Let's continue on. So anyways, I'd asked him to write a little narrative, what had happened. And this was him and his wife, and the house is in his wife's name. He had dropped her off at the courthouse door, and then he had to go park farther away. So by the time he got back, they had already started the proceedings, and she was basically reading off of the motion that we'll see in a little bit. And then some other stuff happened, but from there, and that's what this has to do with. So let's just go through it. So I recently discovered in a loan disclosure the APR finance charge were understated well outside federal regulations, and argued that the loan was taken by assignment by the holder of the note, the plaintiffs having Truth in Lending Act violations on the face of the disclosure, making new assignee responsible for the violations. I showed the calculations using the FFIEC calculation tool, right? So FFIEC, if you Google, it's an acronym for some federal financial something or other. And they have a calculation tool to do APR, right? So he used that, showing that the understated APR and the understated finance charge, the APR being understated 2.2% and the finance charge by $81,000. Well, if you filed this, anything I said here recently, on T.I.L.A, then you know that the finance charge cannot be understated by more than $100, sometimes no more than $5, and in the case of a foreclosure, no more than $35. And yet it was understated by $81,000 when you use the calculation tool at FFIEC. Now I'm going to qualify that and say that's if you do it one way, but if you check a box, it changes the thing. We'll get to that in a second. But true enough, you can do it and end up with these kind of numbers, which is good because all you have to show, all that has to be wrong in a foreclosure for you to rescind the contract that caused all this stuff to happen is the the finance charge to be understated by more than $100. Right? So keep that in mind. The goal is you want to rescind the contract. Because by rescinding the contract, we're going to get back the collateral, which is the house. And you put your house in the mortgage, and in your mortgage it says you transfer the rights to the house, and they record that. So that they just made your house the collateral. So part of this is you got to get when it's all said and done, the mortgage has been recorded in the Register of Deeds office in this case. It would have to be removed. We're not there yet. So anyways, so he showed the calculations, right? The defendant showed where plaintiff concealed the violations by their own affidavit, saying they had firsthand knowledge of the loan and the numbers. The plaintiff argued that they are holder of the note and claimed the year of statute of limitations was passed. Okay, so, defendant's got his thing to say, plaintiff's got theirs, and then in a moment, they're being silenced. The judge stopped proceedings, went off record, called the status conference, together with plaintiff and defendant. After both parties agreed, the judge stood up and stepped down from the bench, walked up to the defendant's table, prompting quick action by the courtroom assistant, wheeling a chair to the table opposite the defendant's. Right? The judge walked to the defense table, and somebody brought him a chair. The judge took a seat with defendants, asking if he wanted to stay in our house. We responded, yes, of course. The judge, acting in a relaxed manner and off record, began telling us how big a system the mortgage company is and the vast number of accounts they possess. And every day the courts see people facing and defending losing their homes. I responded to that by asking how many of those people have federal violations. The judge throws up his hand to say, we're not dealing with that. The goal here is to keep you in your house. He then, saying the attorney cost of the case is getting rather expensive and need for getting the matter settled, he turns to the plaintiff, instructing them to work with us to stay in our home and emphasize the importance of listening closely to what the attorneys have to say and how it's not the usual process taking place. The judge then says these good attorneys to have work with us, making the comment not like some of the other ones. These are good attorneys to have work with us. Making the comment not like some of the other ones. The attorney said not to talk with anyone from the mortgage company if the mortgage company were to contact us. We need to inform the plaintiff's attorney immediately. And that they were happy to help keep us in our home, as the demeanor turned about face from a couple minutes ago, trying to take us out of our home. The attorney initiated a handshake. We shook hands with the judge, and we're all standing together at this time in a non-courtroom atmosphere. And we, the defendant, strolled out into the sunset of the building. So, having thought about this now since this has happened, right? Because at first I said, well, the judge, he actually did that. He got off the desk from his perch, went down to the galley there and sat with the defendant. But then they left, and the case. So he didn't dismiss the case, or he didn't adjourn the meeting, or he didn't. What else would you say? Right? So who knows what happened after the defendants left and left the attorneys in there with the judge. But, that's what happened. So let's continue on with the story. So unfortunately, out of all that came out of it was a couple days later, the attorneys have gotten a hold of the defendant and offered him, mortgage assistance and so forth, which is not what the defendant wants, right? He wants to rescind the contract. So I believe that the judge said that they would have another hearing in 2 weeks, right? And so in between there, the parties are supposed to settle. That's what the judge wanted to have. He wants the parties to settle. So in that case, it's like, well, okay, this is just their first offer. Will you take this? And, I don't know what the homeowner wants to do. I haven't talked to him about it yet, but I am going to. And I'm going to say, well, no, you don't want to do that, obviously, because I know he doesn't want to. We'll write him back, say, no, we don't want that. We want to rescind the contract. Right? We want to get the note back. We want to cash out the note. And that's another great thing about this. We're going to get to see documents that you may not have seen in the condition they are before, mainly the note, where it's got all these endorsements on it that made it into a check. And so they can't give you back your original note, but they can give you back a check that started as your note. And you go deposit that thing and cash it. So let's continue on. Hang on again. So again, then just after they put in the original this motion for estoppel, right? A couple days later, this gets filed by the plaintiff, where the plaintiff's motion for summary judgment, and the defendant's motions is that here's all these motions that the defendant had wanted to have heard since back in July, hadn't been heard yet, or back in February 2025, back to July 2024. Put in something about estoppel, all of a sudden, boom, we're going to have a hearing. But they weren't doing this on the motions of the defendant. They did it by the plaintiff. So how come they never hear your motions? This is the point. I'm going to show you something else here in a second on that. Okay, I see now why they called this one notice of withdrawal of estoppel filing, which isn't really what it was, but that's what he put on the first page, so that's what it became. Right? These almost had to be done as separate filings, and they just put it all together, whatever you file, and say, well, that's, it's under the title of the first page. But in reality, he's putting in a change with the affirmative defenses, where he put in here about the T.I.L.A. and using the FFIEC and doing the calculations, and all that stuff was now in the record, right? Just, I don't know, it was necessarily put in there exactly right, but it got, it got a hearing. And it apparently got the plaintiff to file exhibit and affidavit of debt. Let's take a look at those. Okay, supplemental affidavit in support of plaintiff's motion for summary judgment. I, Brian Cox, am a foreclosure manager, regular business, service mortgage loans. According to the records, plaintiff is authorized to enforce the negotiable instrument secured by the mortgage. Now, isn't that interesting? See, he called it a negotiable instrument, and they're talking about your note. Well, when you gave him the note, it was just a private note. It wasn't a negotiable instrument. At least we weren't told it was. But actually, when you read it, it says on there that you are going to pay them this amount of money, whatever it is, and then they end up turning it into a check. It also says pay the order of on, and all the other attributes that make a check a check. We'll see it here in just a minute. But anyways, he's acknowledging that there is now this negotiable instrument in this transaction. In the course of my day-to-day duties, regularly work, documents, okay, I obviously can't read all this. So my procedure in executing affidavits is to review the business records, particular loan, review the affidavit, ensure accurate, review exhibits attached. Okay, so you're saying you're responsible, and this is true, accurate copies. And now this is your testimony. So really, he's doing a deposition. That's what this is supposed to be, is a deposition. Self-deposition. Plaintiff's records indicate that on a particular day, this promissory note, which is now a negotiable instrument in the sum of $153,174, right? So that was signed. True and accurate copy is attached here to incorporated Exhibit A. Plaintiff's counsel shall have the original note in his possession at any hearing regarding foreclosure. Well, that's good to know, right? So I mean, like the day they had this hearing, the attorneys must have had the note with them there. Well, we need to ask for it next time. We want to see it, because that would prove if they don't have it, then they're really not the plaintiff's attorney. You get what I'm saying? It says that they have it. So show it to me. The plaintiff's records further show a loan was secured by a certain real property. All right, so they just turn your property into collateral. Records show the signed a mortgage dated on some date, secured the loan amount of that much, and encumbered property as collateral. There you are. Through an accurate copy of the mortgage. Then it's been assigned, then it's been assigned, then it's been assigned. I have also determined that plaintiff provided the original note to plaintiff's counsel, and the plaintiff's counsel did in fact receive the original note and is in custodial possession of the original note. And they're supposed to have it in court, so where's the frickin' note? They ain't got it. Then the people sitting there are not the counsel of the plaintiff. Right? It's a scam, which we know that it is. Here's the proof. Last valid payment pursuant to loan account was, and they go through what the amounts were and what's been paid and so forth, right? Tally it up. As a result, defendant's default under the note, mortgage sued upon herein, the plaintiff retained the attorney of record and authorized filing this action, right? So now they call this guy the attorney. They didn't say he's the counsel. Now they're the attorney of record. So the plaintiff's counsel is not the same as the attorney of record. Right? And an attorney can sign for you. I could sign for you. I could be your attorney, right? But to be counsel, you have to have a license because you're going to give legal advice. Further, plaintiff has agreed to be bound and obligated itself to pay said attorney his services, such sum as court shall adjudge to be reasonable. Document also authorizes attorney of record and his representatives testify on behalf of the plaintiff in this foreclosure action. Okay, but then we get to this part, and this was foregoing. This was acknowledged and sworn. Well, we're not going to do that. We're going to cross that out. And instead, we're going to slap this on the back, where this says it was subscribed as sworn, not acknowledged as sworn. And this said it was Carrington Mortgage Services, LLC, and this don't have nothing on there. So technically, this piece of paper ain't got jack to do with this. They just put it in behind there so that you think there's something there, but this could easily be removed because it isn't attached. It says see attached. Well, it's not attached. I don't see those staple holes. You know, it's more Esquire games going on all the time. Now let's look at these exhibits then. These are what he was talking about. So here's the note. Well, it certainly can't be true and correct copy because it got stuff blanked out. Right? So I don't know why these things are blanked out if this is supposed to be a court record and they have things with all sorts of other information on it. How come these things have been blanked out? Blanked out. But it says here, in return for a loan that I received, I promised to pay, and it gives an amount. Well, that makes it a check. You promised to pay. Or it's the beginning of a check. It is a check because now we're going to endorse it. Without recourse, pay to the order of. Well, that definitely is wording on a check. Right? So, Howard Residential Incorporated got paid by NTF Incorporated, right? These are the original people here. Now they gave it to this Howard Residential. And Howard Residential now was going to give it to MB, whoever that was. That got voided out. Oh, got more of that going on. Now we'll add some alliances instead. And so here's Howard Residential Incorporated. Going to pay the order of somebody else, right? So all this is supposed to be in the courtroom or wherever the proceedings are with the plaintiff's counsel. And they all show that the note has been turned into a check. All right, now this is the filing of with the Register of Deeds of the mortgage. And again, this isn't, true and correct. It may be true and accurate, whatever the hell that means, right? But it's certainly not true and correct because they have all this stuff blanked out. This isn't how it's blanked out. You can go online into the Register of Deeds records and you can find this document, and none of these blanked out parts have been blanked out. So why are they blanked out when it went into the court case? But see there, transfer of rights and property. That's what made your house, your property, collateral. because you sign a piece of paper that transfers the rights to the property. Now, this document, it's not really a business contract of any kind. It's a unilateral contract, which can only be used for gifts and donations, right? Because there's only one party signing it. So that's the difference between unilateral and bilateral. A bilateral contract is a business contract where both parties sign or multiple parties sign. Unilateral, only one party signs. But a unilateral contract can only be used for gifts or donations from the person who signed it, not for business. And they got real dinky little writing here. Filed, recorded February 26, 2016, Dorchester County Register of Deeds. Right? Gives a book and page number. And this shows it was filed in the court case. So they filed into the court case something that's had all these identifying documents. Well, most of these are like barcodes, right? This is it's an altered document. And so, yeah, before I forget to point it out, right, who are the defendants, right? We got the homeowner, the state of California, and the guy that they got the property from before. And well, how come the other people? Why isn't the state in court? And then this is that Liz Pendens that, kicked the whole thing off. And the reason I want to show this now is that here it has the legal description of the property. But when you look at this and you go back and say, well, let's go look at the Exhibit A, right? If you were to look at these two different documents, you would see that this, in the entirety, they're not the same. Like this part right here has been taken out, where it talks about, in these people's case, that something's been put in a book and a page, right? But not in the case of the current owner. There's been nothing put in a book and a page like there was for the transaction previous to this. So they're always like one step behind. If they were to foreclose on these people, then the next person would have a statement like this on their property, and instead of like this, right? That we're not going to put it in a book and a page. We're not going to make it. It's administrative state doing what it does, right? Slow walking the paper. Never got there yet. Although they did everything that should have been done for it to be recorded, because it says it has been, they don't have a book and a page on there yet. Okay, so remember where we are with this, right? The whole reason that the defendant put in called an estoppel, but a motion, dismiss the case or whatever. I had to put in motion to rescind the contract, thinking about it now, right? Because that's what we're here for. That under a foreclosure, so look at 12 CFR 1026.23 H, right to rescind after initiation of foreclosure on consumer's principal dwelling. This secures the obligation. The consumer can rescind it if a mortgage broker fee should have been paid. If the creditor did not provide properly completed model form, Appendix H. Should probably look at that someday. Tolerances, right? After initiation of foreclosure, the consumer principal dwelling and secures credit obligation. Disclosed finance charge is considered accurate if it is understated by no more than $35. Well, the dude said it was $81,000, and no one said, no, you're wrong. Your math is wrong. They didn't say that. They said, oh, we're not going there. We're going to try to keep you in your house. Well, that isn't what we want to do. But don't argue with the judge. Right? The judge sent him away to go work it out with the plaintiff, and that's what we're going to do now, or he's going to do. I don't want to speak for the man. I'm just saying, you're still where you were when you went in. Say, oh, no, I want to rescind the contract. Right? This rescission is, what do they call it? Administrative enforcement action. So if you remember in what we've read about T.I.L.A up to this point, that there's federal regulators that are supposed to be enforcing the truth in lending, right? Which includes the Office of Comptroller of the Currency, the FDIC, and the Board of Governors. What it doesn't include is the Consumer Financial Protection Bureau, because the CFPB does not exist in law. There is no Consumer Financial Protection Bureau. There is, however, supposed to be a Bureau of Consumer Financial Protection. That's supposed to be the one doing all the things that are talked about in the law, but you can't find that one. They said they send you to the Consumer Financial Protection Bureau, which I've already hammered that thing enough, but nevertheless. So what are these enforcement actions that they can do for you? Yeah, here we go. Enforcement action types. Capital directive. I don't know if that would help us. Cease and desist order. Well, that could help because they, couldn't take your money anymore. A restitution order. Take affirmative action to correct and remedy any conditions resulting from the violation of unsound practices, including requirement to make restitution, civil money penalty, 3 times damages, right? That kind of stuff. Yeah. So if you're going to rescind the contract, then I want restitution to go with it. All right, so if what you wanted to do is what it says here, right? You want to rescind the contract. And the judge has now told the defendant and the plaintiff's attorneys to go work it out. And the attorneys come back with, yeah, we can help you out, stay in your house. And, if they want to just do a request for a mortgage assistance and get your tax information. Well, how are you going to get what you want when this is what they want to do? That's where we're at now. Right? So we already know it's a federal crime. And I'll show you even more here in just a second. But it's also a state crime, because if you go to your Consumer Protection Act, and these all read a little bit different, but some place there's going to have fair, unfair, unconscionable, deceptive practices, acts, practices, methods. Yeah. And look at this: causing or probability confusion or misunderstanding as terms or conditions of credit if credit is extended in a transaction. Well, that's, if you read the truth in lending statement, that's what this is all about. It's all about credits. So, and they say the finance charge is supposed to be so much, and when you calculate it using their annual percentage rate, you find out that the finance charge is way off. Now, the defendant used the tool, the online tool, but finance charge itself is the formula for finance charge is take the APR and turn it into a decimal point, because it's a percentage to start with. Turn it into a fraction or a decimal point. Multiply that by the amount that was financed, and multiply that by the term in years. So if it's a 30-year note, well, then 30 years, right? You multiply that together, and that's the finance charge. Well, to figure out the APR, they have to, instead of having such a simple way to do it, APR, you have to do this whole big-ass mathematical calculation that's pointed out in the Regulation Z, which is the Truth in Lending Act, in Appendix J. Right, so I don't want to argue with them about, because both the APR and the finance charge are on the disclosure form. So I'm going to say, okay, well, I'm going to agree that your APR is correct and show you that based on that APR, your finance charge is incorrect. Because there's nothing in the T.I.L.A about how to calculate the finance charge. And if you go ask AI, which is what I did, which, and say, well, how do you calculate finance charge? It'll tell you, well, just what I told you, right? You need the APR, you need to have the amount financed, and you have the term. Multiply them together. That's finance charge. It's pretty simple. And when you do it that way, you'll find out like this gentleman did, right? The $81,000 understated finance charge. Well, I would say it's a crime, right? So anyways, this is that, back to what this is. So It's a violation of the Michigan Consumer Protection Act, and the Michigan Consumer Protection Act is enforced by the Attorney General and the county prosecutors. So one thing is to file a complaint to say, well, go file a complaint with the Attorney General or and with the county prosecutor. I'd probably start with the county prosecutor. Right? Action to restrain defendant by temporary permanent injunction. Right? If the Attorney General has probable cause, da-da-da-da. Well, you know what the probable cause is? To show them that the finance charge is wrong. Calculate the finance charge. Now you're giving them proof. Right? And then it says a prosecuting attorney can do it. Right? So either one. And I've not had any luck going to the Attorney General before, but I've not tried anything with the prosecuting attorney. So I'm just saying, if it's the same complaint, send it to as many places as you can. Class action by consumer or by Attorney General. And then at the end of the day, you can actually open up your own court case and go for it that way, right? But I just soon have the Attorney General do my lawyering for me. Right? A prosecuting attorney may conduct an investigation pursuant to this act and may institute and prosecute an action under this act in the same manner as the Attorney General. So this is like, well, this is all fine. This should work really good, right? The problem is, if you ever dealt with the state, well, they lie as bad as the federal government, probably worse. Right? The administrative state goes all the way down to your local township board meeting. Right? City board. It doesn't really matter. Whatever the smallest government is, all the way up, it's been consumed by the administrative state, run by Esquires, which by definition is a crown agent, and taken over by England. However, as it turns out, we can see what the law said in Michigan, and so, Michigan law isn't going to work in South Carolina, but South Carolina's got their own law that does the same thing. So if they don't do what the law for deceptive practices says to do in South Carolina, well, then you've been denied due process. And that falls under the 14th Amendment. And as a show, it's a component of a federal criminal law. So this book is all the different things that make up what's known as federal criminal law, and federal criminal law is what the FBI enforces. So if you could say, well, the local prosecutor didn't do a investigation, or in this court case that the gentleman's in now, the foreclosure, they continue on with this shit. When he's already asked to have a rescission, it says right in the law you can if they don't give them to him. Well, that's, denial of due process. And so in there it gives all these different, breaking down what federal criminal law is. And it talks about these Reconstruction era amendments, the 13th, the 14th, and the 15th. It's just really quick. I want to look at the 14th Amendment. Not the 14th Amendment citizen portion, just the 14th Amendment. Where it says, in relevant part, the 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person, right? Now you don't have to be a citizen of the United States, just a person, of life, liberty, property, without due process of law, or deny any person within its jurisdiction the equal protection of the laws. Section 5, 14th Amendment grants Congress power to enforce by appropriate legislation the provisions of this article. Then it says, there are two important limits to Congress's Section 5 power. First, the Supreme Court has indicated that the 14th Amendment, by its very terms, prohibits only state action. Right? So that's the point. This is something being done by the state. Well, that makes it a 14th Amendment violation. So it's a violation of the Constitution. Accordingly, Congress' power to enact legislation under Section 5 is limited to legislation addressed at remedy of state action. Well, there you are. We're in a foreclosure. That's a state action. State action may become may come in a number of forms, perhaps most relevant to criminal law context. State action requirement may be satisfied where an individual acts under color of law. That's what's happening right now. Generally, an individual's actions under color of law if their conduct involves a misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law. That'd be like a judge or a lawyer, banker, right? Somebody that's got a license to do what they do. Typically, individuals acting under color law will be government employees or officials. Well, ain't that something? That's exactly what we're talking about. There are also some instances which conduct private individuals' entities may be attributed to the state itself, although determining whether that is the case is necessarily fact-bound inquiry. The Supreme Court has said there must be close nexus between state and challenged action, so seemingly private behavior may be fairly treated as that of the state itself. Okay. Well, what I know is the ones we're talking about are claiming to be the state, right? So I guess if this is the answer of the attorney, then to go back and say, well, no, we don't want to do that. We want to do this here. And if you don't do this here, we're going to go file a complaint here, or just go directly to the FBI and file a complaint with the FBI about the court case, because it's denial of due process, right? And make it that it's a violation of the Constitution. So that's kind of where this is today, right? That, it was an odd day to have a judge leave his perch and go sit down there at the defense table. And at the time when I was first being told, oh man, the guy's going to help he's going to help the defendant out. And I'm not saying he didn't and hasn't. I'm saying that there's another game going on now where they just want to get these people to accept a revised form of a loan. And I don't think that they're quite ready to do that. Now, I don't know how much pushback there'd be and how hard they're going to be, because they're going to make it sound like you're the one breaking the law. Which is why I said, well, how can I be the one breaking the law? I filed a complaint with the Attorney General. Right? So either we can rescind it now, or I'm going to have to go file that complaint. Because all these things are crimes, and once it becomes a crime and you get the Attorney General involved or the FBI involved, well, their ass is going to jail, right? So you have all sorts of leverage to get them to do the right thing, as long as there's somebody in this chain of command that will do the right thing for us. And that's what we're trying to find. Who's the one that has to do the right thing? Have we found him yet? Okay, let me think for a second if I got any more, and I'll come back and finish this up. I did want to mention state status conference, what the judge said he's going to have. What is that? It's sometimes called an early conference. It's a court-ordered meeting with a judge where a trial date is decided. The meeting may also involve getting updated information on the defendant for ongoing conditions set forth previously by courts, such as house arrest, house monitoring. It can also involve discussion of plea bargain or result in a settlement. So whatever it is, it's pre-trial, right? So how is it that you can be pre-trial and lose your house, right? And what is the trial? Because he isn't there yet. But that's what it was, status conference, and hopefully for settlement. And we'll see if that's what the plaintiff wants to do. It's just, we have what we want to settle for, and they have what they want to settle for. See where we end up. Okay, y'all have a great day, and see what happens next. See ya.